We are honored to open the summit with keynote conversation between two distinguished guests whose perspectives on law and policy are especially meaningful to the groundwater community. Chief Justice Nathan Hecht, who many of you will remember joined us 8 years ago on this same stage, returns today to share his insights after a remarkable career on the bench. He's joined by Drummond, his longtime friend and former law clerk. Dylan is an appellate equity shareholder at Langley and Bannock. We've designed this keynote to be more of a conversation, and Dylan has asked to introduce himself and the Chief Justice himself. Please join me in welcoming both distinguished gentlemen to the stage.
Well, good afternoon. Thank you all so much for having us. I very much have no desire to introduce myself, but I'm happy to introduce the chief, although he certainly needs no introduction. My name is Dylan Drummond. I'm an appellate equity shareholder here in San Antonio with Langley and Bannock. But the best job I ever had was the year I spent and was privileged to serve as one of our keynote speakers' 74 law clerks that he mentored during his record 36 years on the Texas Supreme Court bench. During his landmark tenure at the court, to which he was elected to serve an unprecedented 7 times, he served with some 40 fellow justices, among whose ranks have included a future U.S. attorney, a future U.S. Attorney General, White House counsel, U.S. Senator, U.S. Congressman, 2 judges of the U.S. Court of Appeals for the Fifth Circuit, including its chief judge and his future spouse, 3 U.S. district judges, a Texas governor, and 2 Texas attorneys general. But a San Antonio native and current Texas Supreme Court Justice Evan Young has observed our keynote speaker's tenure at the court is historic not just for its record-breaking length, but for its significance. Quote, no judge on any Texas court from the days of the Republic onward has been more consequential. To this end, his significance to Texas groundwater law is exemplified by 2 of the more than 500 signed opinions he authored while he was at the court. First, of note to this audience, his 1999 concurrence in Cipriano v. Great Spring Waters of America, in which he cautioned that, for now, but I think only for now, the court's historic 1904 opinion in Houston, Texas Central Railway v. East, which adopted the rule of capture in Texas, should not be overruled. And second, his unanimous 2012 opinion in Edwards Aquifer Authority v. Day, in which the court confirmed that overlying landowners have a constitutionally compensable interest in groundwater, which they own, quote, separately, distinctly, and exclusively subject to the rule of capture. Accordingly, it is my distinct honor to introduce our legendary keynote speaker today, one of the newest partners at Jackson Walker and the 27th Chief Justice of the Texas Supreme Court, Nathan Lincoln Hecht.
Thank you very much. Thank you.
I will begin by noting that the judge, I believe, was first elected to the trial bench in 1981, so about 45 years ago. So after 45 years, I expect him to take more than 5 months of a break from practice prior to entering private practice. We are glad to have you back amongst the billable life of attorneys. So, welcome back. Also, before we begin, I want to let everyone know that the chief has a hard out today at 1:45. So we're going to chat about a few topics. We're going to try to leave some time for questions and answers, but we are going to try to get him out of here by 1:45. So the first topic, and again, thanks to the organizers who submitted to us several ideas that we've kind of drawn from, and the topics that we're going to discuss today. So we'll start with Day, the court's 2012 opinion, seminal opinion. The court observed that while groundwater resources are undoubtedly subject to regulation under the Texas Constitution's Conservation Amendment, such regulation must be balanced against the Takings Clause of the Texas Constitution, regardless of whether required compensation makes a given regulatory scheme more costly. Now we're over a decade out from Day and a quarter century after Cipriano. What observations do you have regarding how groundwater conservation districts can navigate potential regulatory takings claims?
Well, thank you, Dylan, for all the kind words, and thanks everyone for inviting me here this afternoon to visit with you briefly. The landscape or waterscape of the law continues to evolve. I think one of the big steps that we don't often think of in the groundwater community was the U.S. Supreme Court's Keynote decision, a takings case in Connecticut in 2002 or 04, in the early aughts. And you may remember there was a condemnation of some property to make it basically a shopping center. I'm oversimplifying it, but that was kind of the gist of it. And query, could the government really do that to further pretty much economic interests of others? And there was a big debate, and the Supreme Court held that there wasn't a taking. And that's kind of made Texas judges a little uneasy. We've already, the Supreme Court of Texas has always said, Penn Central, that's the law, the federal law, that's the law here. It almost has to be, because what's the alternative? It would be too much confusion if there were one rule in the federal courts and another rule in the state courts. But our Constitution is different. We've said it uses the word damaged, that the U.S. Constitution doesn't use. So I think it's there's still some protectiveness of individual ownership rights that continues to grow, and maybe it's a little stronger in Texas than some other places. That, of course, affects groundwater regulation, as Day indicates. But I think all that means is that when you're thinking about regulation in a particular area, you've just really got to think through, can I really make a convincing case that the balance we're drawing here, this kind of regulation, these kinds of restrictions, is justified by the constitutional amendment, for one thing, but by the use of the greater community. So it's, it's reasonableness. It's kind of, there are not a lot of bright lines, but I think what it means for groundwater districts and other regulators is, when you're thinking about expanding regulation, you need to think about making a good case.
Absolutely. We'll stick with Day. The court was actually pretty deft in Day, both in distinguishing and reconciling the doctrines of the rule of capture and absolute ownership, noting first that the rule of capture determines title to groundwater that drains from property owned by one person onto property owned by another, but says nothing about the ownership of groundwater that has remained in place. And second, subject to the rule of capture, which prevents overlying landowners from being, quote, entitled to any specific molecules of groundwater, even to any specific amount, each owner of land nevertheless owns separately, distinctly, and exclusively all the groundwater under his land. Do you feel the balance the court struck in Day is still workable today? And how, if at all, might the legislature address any imbalances that have arisen?
Yeah, I mean, we explained in Day how the ownership in place and the rule of capture could coexist. And basically, just looking back on it, the rule of capture was a kind of regulation. It was an idea of how much it was sort of self-regulation, but it was how much could people pump from their land, were there going to be restrictions on use and those kinds of things. That doesn't mean that there was any lack of ownership in place. If under the rule of capture, everybody in a aquifer, in an area where there was underground water, was pumping all they could, then the rule of capture would mean everybody got exactly what was underneath their property, more subject to differences in the formations and that kind of thing. It's as we said in Day, and I'm still convinced, It's not that there's incompatibility or a lack of coherence. It's just that the rule of capture has outlasted its usefulness. No other state uses it. I said in Cipriano, as you said, Dylan, we have it for now, but only for now. So I think here we are, a quarter of the way into the 21st century. We need to think about more vigorous groundwater regulation in Texas. And we thought that in Cipriano. We thought it was too soon, but surely by now.
We'll move to Cipriano. You observed back in 1999 that despite the Groundwater Conservation District Act having been passed a half century earlier in 1949, quote, not much groundwater management is going on. I think everyone in this room can agree that has largely changed thanks to the tireless efforts of everyone here. How would you assess the groundwater management efforts that have been undertaken in the intervening quarter century since Cipriano?
Well, I think they're much stronger. When we wrote Cipriano, that was in 1999. In 1997, the legislature had passed, for the first time in a while, some pretty important groundwater regulation, groundwater districts, and there had been pressure to do it for a while. And there was still more pressure in 1999 when we decided the case. I told you this story 8 years ago when I was here, but it's too good not to tell again. When Bob Bullock became governor of Texas, Governor Bullock was a lifelong, staunch, deep blue Democrat. And Tom Phillips and I were young, wet behind the ears Republican judges. And he immediately loved us. I don't know why that was, but he would always call us over to talk, and he'd call us up and he'd say, boys, come over here. So we'd trundle across the street to see what the governor wanted. And when we put Cipriano out, he immediately, went out at 9 o'clock or 10 o'clock in that morning. He called us immediately. He says, boys, come over here. So we went over and he said, I just want to congratulate you on the Cipriano case. He says, you left groundwater regulation to the legislature. That's where it belongs, and it's good that you saw it. Sometimes courts are always trying to take over. It's a good thing that you did. Oh, well, thank you, Governor. And then the next day or so, we pick up the Austin American-Statesman, and there's an editorial in the paper quoting Bob Bullock. Well, the court really let us down this time. They had a chance to help people fixing water regulation, and they just pushed it off on the legislature, so we'll do our best. And we went back over there and said, Governor, I thought you thought we did the right thing. He said, oh, I do, but I was just funning you boys to see if you could take a little criticism in the press. And we said, well, thank you, Governor. I mean, he felt he was just struggling to get legislation passed, that groundwater regulation needed to be more vigorous. And the rule of capture kind of impedes that. And if I were writing Cipriano today, so I can say this because I'm not on the court anymore, but if I were writing it today, I'd go the other way.
Absolutely. If you can prognosticate from your years on the bench and knowing all your former colleagues the way that you do, this is a submitted question that we had given to us. If and when do you believe that the Texas Supreme Court may take a more active role in shaping water policy? Speaking of how Governor Bullock had praised you for being inactive and then criticized you for being active.
I think that there's going to be a reluctance on the Supreme Court of Texas and throughout this Texas judiciary, I think, to engage in any kind of very active groundwater regulation because of Article 16, Section 59, and says the legislature should do it. And we said, well, that's right, the legislature should do it. And the legislature's come along and said, that's right, we should do it. So I think, there might be interstitial cases that, for example, I think in the Coyote Ranch case, we applied the accommodation doctrine to groundwater, even though it usually applies, obviously, in oil and gas. So I think there might be some of that. There are going to be cases where the court's going to decide the regulators went too far and there may be a taking here, or the regulators did not go too far and this is exactly what we need. I think there might be decisions like that, but I think the precedents and the Constitution and what we've said so far mean that most of it is going to be in your hands and in the legislatures.
When you were growing up out in New Mexico, understand that your family had a well and had groundwater on your rural property. I believe you were raised on a wheat farm.
Yes.
And I know your father had very strong feelings about the price of a bushel of wheat. There's pictures from the chief's from his investure as an associate justice. I believe Justice Anthony Kennedy swore you in January of 1989. There's a picture of your father there with very long hair, but there's a reason why he had a long ponytail. That wasn't his fashion choice, but you might speak to that briefly. But having grown up on a rural tract, relying on ag for a lot of your family's income, do you have any insight from that through your judicial service as to the importance of groundwater to overlying landowners?
Well, the story about my dad is that my dad was a great man of principle. It was kind of, he had different principles, but he came in one day from having gotten a haircut, and he said, I'm never getting a haircut again if it costs more than a bushel of wheat. Well, that was in the early 70s, and he died in 1990, and it never got over a bushel of wheat. So his hair is down in the middle of his back. But it was crucial, I mean, for us living in Curry County, New Mexico, right on the Texas border, we were one of the first. We had one of the first wells. We think we were the first well in Curry County in the Ogallala, and it was revolutionary because nobody thought you could pump water 440 feet beneath the surface. And when you could do it, suddenly land went from 7 bushels an acre of wheat to 77 or 100. It was astronomical. Then, of course, the price of natural gas caught up with everything, and then you could only pump what you could afford. But it was the lifeblood, and that's always the way it is. And the hard issues that you all deal with, and that the law tries to deal with, are when there are competing needs. Sure, you've got to think, these folks have had a pecan farm like in Bragg for a long time. Should they have it forever? I don't know. You got to think about that. In other circumstances, they're just going to be times that change. I thought the Ozarka was a really hard case because they were just using so much water. But that's just we're going to have to continue to weigh the San Antonio's need for the Edwards Aquifer versus the surrounding farms and ranches. It's always going to be hard.
Absolutely. Well, before we open it up for questions, I do want to make a quick pitch. Now that the chief is back in private practice, anytime that there is a groundwater issue, up before the Texas Supreme Court. The only lawyer that you need to be hiring in the entire state of Texas to brief to that court, either on the merits or as amicus, is the man sitting right here. There is no more authoritative voice who's been there, done that, written on it, has developed the law on it than Chief Hecht. So while I selfishly would love to have all that business, it should absolutely go to Chief Hecht.
I'll just refer it to Dylan. So I didn't pay him to say all that.
No, absolutely not. In fact, he did not know I was going to make that pitch. Does anyone have any questions for Chief Justice Hecht? And we're fine if no one does, because we can give you time back. But
I'd be interested. I really I'm curious about your program because the science is always changing, and it has evolved so much from the relatively simple situation that I grew up in on my farm, my family's farm, to what we have now. And it'll be interesting to see how conservation and preservation, allocations and exploration will all run together to set the stage for things ahead.
absolutely. Any questions for the Chief before we wrap up? Please. I can bring you a mic.
Oh, she got one.
No, I've got it. Okay, this is interesting because I'm going to moderate a panel right after this. So I wanted to ask my panelists this question too. So I'll ask you, Chief Justice, in the Day case, where you write that landowners, that one responsibility of groundwater conservation districts is to afford landowners their fair share of groundwater. Can you explain what that means?
Say it again.
The question was, can you explain what you meant in Day when you said that that overlying landowners are entitled to a fair share of groundwater? That is not a loaded question at all.
Well, what we meant. I mean, I think we said what we meant, but and I don't mean to add to it. But the fair share is a loaded question, and you get that. We're speaking in a context of the rule of capture, where arguably under that rule, fair share is whatever you can pump out of there, even though it's a whole lot more than was physically beneath your property. But I think what Dave was trying to say was that you can't just take it all. You can't just take it all away by the government or other users just for the taking. There's going to have to be a balance. It can be the balance that the rule of capture strikes, which is not much of a balance, or it can be a balance that groundwater regulation sets. But the importance of Day is that you can't say, well, the balance is you get it all and you don't get any, even though you've got some below your land. There may be reasons to allocate more one way or another way, but those are going to have to be reasonable, and they're going to have to be stated. And that's why I think that the only solution, and I told Governor Bullock this at the time, even though he was on my blacklist there for a while, but I was telling him this is up to the legislature and regulators, because in the end, someone asked, one of our questions was, should we substitute reasonable use, the old restatement second, 858, should we substitute reasonable use for rule of capture? Well, the courts deal with reasonableness all the time, and it's how long is a piece of string. And reasonableness works pretty well in car wrecks, and then sometimes not so well. But reasonableness obviously looks different to different people, and there ought to be some sort of community input in saying this use of water is better for us all, including the landowner, even though it may impinge on his selfish interest. and for the state. Arguably, and I think this is true, Section 59 was an expression of the people that even though you've got water under your property, at some point the state has an interest in how that's used.
Any other questions for the chief? Yes, sir.
I tried not to ask a question, I promise. Under the rule of capture, you cannot hold your neighbor liable for damages caused from them operating your well and on the damages on your groundwater. Does the Day case and the Bragg progeny from that open the door so that a district issuing a permit that allows that drainage can be held liable for that drainage? And by the way, this question's already being litigated in a federal district court.
Yes, I think it does open the door. So, and that's kind of what we were worrying about in Cipriano. Was there a door, or did the rule of capture slam it shut? And the majority opinion, Justice Enoch, I think, indicates that, you know, there's this and there's that, and you got to kind of look at different things. And then the concurrence comes along and says, well, maybe the rule of capture is doing more harm than good. But I think the Day lays another card on the table. I think it was always in the deck, and that's what I think Day says, is that the kind of the substructure of the case law was that there's some ownership, there's some private ownership underlying all of this. Otherwise, you don't care about the rule of capture. And so I think it's an issue. But again, if it is an issue, the community, the government, can take private property and divert it to public use. And that's Penn Central. And you can do it through regulation. And if you take it all and say for the better of the community, you don't get any anymore, then you're probably going to have to pay for all of it. But if you restrict the use under Penn Central, you're going to have to restrict it a lot to really state a taking. And that's, yeah, I think those are issues that are out there. Again, my sense is that the federal courts are less, they're less inclined to find a regulatory taking than the state courts are going to be. But I could be wrong about that. That's just, I think they see Penn Central as a bar, and the Texas judiciary thinks of it as an impediment, as just another consideration.
Any other questions for the chief?
Well, I think, yeah.
So the question concerned the difference between riparian rights with overlying streams and rivers, you know, ownership of that water, the ability to regulate that water compared to ownership and regulation of groundwater, and why there's a difference there. Correct me if I'm restating incorrectly. And when did the legislature confer the power on the state to regulate groundwater underneath private property owners' land?
Well, I think that's Article 16, Section 59. I think the people said in the Constitution, this is the way it's going to work. With respect to surface water, it belongs to the state, and that's the end of that. But with respect to groundwater, it is the state has less authority over it, but under Section 59 has some.
and I'm sure this is of very little interest to most folks in this room, but it's provincially interesting. The justice who wrote the seminal opinion as regards riparian rights was here in San Antonio. Future Chief Justice, one of your predecessors, Jack Pope, when he was a justice on the San Antonio Court of Appeals, and it was so good when he wrote it for the San Antonio Court of Appeals, the Texas Supreme Court adopted it wholesale. They didn't change a jot or tittle, which almost never happens. And in fact, I can't think of the last time the Texas Supreme Court has pet refused a case, which means that they just adopt it and don't need to say anything more about it. But so the seminal riparian rights case was issued here in San Antonio by the San Antonio Court of Appeals and was then blessed as Texas Supreme Court authority after that. Any other questions?
Jack Pope was a great man.
Absolutely.
He told me one time, there's nothing worse than a dumb judge that works hard. And I didn't think he was talking to me, but I took the point.
I'm a hydrogeologist, and I try to read the day opinion at least once a year because I learn something new every time I read it. It seems like one way of addressing fair share is like a correlative right or a correlative allocation. So, what you have available given a district's goals gets divided out in some way, hopefully equally amongst its users. I mean, is that a viable way of doing it? And are there other ways that protecting somebody's fair share or landowner's fair share could be done?
I don't know of any other way. So you remember in the case law under establishing the rule of capture, I think we said it in the East, but we certainly said it after East. One of the justifications for the rule of capture, there were two. One of them was that you can't see it down there, so how can you tell who's taken what? But the other one was it helps advance society. It's great if the railroads get more water than wheat farmers because they're changing the state going forward, more people are benefited. We didn't say that. We didn't say it quite that bluntly because railroads weren't very popular, but that was the idea. And so now I think that idea still carries forward, and it's just going to be something that we, as a community, as the state, are going to disagree about. And the arguments are going to have to be made, and we're going to have to say, is the state better off, are Texans better off because we're using the water this way or because we're using the water this way? And is there a better way to do that? I don't know of one. That's why I worry about substituting reasonableness for the rule of capture, because I just think you're going from one problem to another, and there'll never be an end of it. I think as hard as this has proven to be, that the people's representatives just need to get together and say, this is a fair way to do this through the community, or groundwater districts through regulation. But the time and chance happen to all, and the idea that you should get a certain amount of groundwater because your great-grandfather was essential to the community, raising cotton or wheat, that can change over time. And I think that's what you're stuck with. That's why you're here.
Thank you, Judge.
If there's no other questions, thank you so much.
We actually have one question. I apologize. I had to walk
please.
back here. Came from online. It says, can you talk about the balance between policy of keeping water local versus export? And is there a difference, in your opinion, on how those should be managed?
And so, again, I think that it's going to be a balancing. If, just take the Edwards. When San Antonio was a smaller place, then I think its claim to more of the aquifer was lesser. And people could, I don't think they didn't do that much back then because the aquifer could service everybody. But as time changes, I think you have to look and see, is there some benefit to the state that the water stays local, that there's some sort of priority given to it, or they get a little extra because it's local, or not? Does the greater state have an advantage? My farm was on the Ogallala, and it stretched up into Kansas, and so we didn't even know that at the time. There was lots of water in the aquifer, and then it went down. Now it's come back up again. But I think again that question is. Sure, I think you have to look at the people who have been there, worked hard, developed the property, expecting that they were going to be able to use the water. I think you also have to look that it's a growing state, and things change, and does that justify a greater restriction on the use? But again, I know this is frustrating when you're dealing with those issues, but I don't see a way around it.
Thank you to everyone for the time this morning. Appreciate it.